Everyone, and welcome to our presentation today, Prop 19, Explaining the Property Tax Impacts. This presentation is co-sponsored by the Real Estate and Tax sections of the Beverly Hills Bar Association. The tax section of the Beverly Hills Bar Association in our event today is also sponsored by Hockman, Salkin, Tosher, Perez, PC. My name is Elizabeth Dryden, and I am the co-chair of the Beverly Hills Bar Association, because of the real estate section of the Beverly Hills Bar Association. And I am pleased to have with us today, Gregory Broege, a partner at Ajalat, Polley, Ayoob, Matarese, and Broege. Greg attended Florida State University, where he graduated summa cum laude and Phi Beta Kappa. After graduating from SFU, Greg attended UCLA School of Law, where he was awarded a Dean's Merit Scholarship. Greg began his practice at Latham & Watkins and later joined Ajalat, Polley, Ayoob, Matarese, and Broege in 2009, where he specializes solely in California state and local tax matters. Super Lawyers Magazine has consistently recognized Greg as a Southern California rising star, and Greg has been recognized as a rising star by the California State Board of Equalization. Greg was also awarded the new Member Achievement Award by the Institute for Professionals in Taxation. Greg has served as chair of the State and Local Tax Committee of the Tax Section of Los Angeles County Bar Association, as chair of the Institute for Professionals in Taxation's Property Tax Symposium Planning Committee, and as chair of the Property Tax Committee of the Institute for Professionals in Taxation's annual conference. Greg has authorized numerous articles and is a frequent speaker on state and local tax matters. And we're very pleased to have him with us today. Before we let Greg take it away, I'd like to let you all know that your MCLE certificates will be automatically emailed to you later today. If you have any questions during the presentation for Greg, please put them in the Q&A box. Thanks all, and Greg, take it away.
All right. Hi, everyone. I'm going to share my screen. Just give me 1 second. So hopefully everyone can see the screen at that time right now.
All good, thank you.
Okay. And just so everyone knows, you, as Elizabeth said, you could put your questions in the Q&A and chat. I will try to answer some of those questions as we go, if it's relevant. Sometimes, you're asking questions that we'll get to later in the presentation. Sometimes there's just not enough time to answer all the questions, or maybe they're a little bit too specific for this specific presentation. So I will be monitoring the questions. I probably won't be able to answer all of them, but maybe I'll be answer some that help the conversation and presentation flow along. Before I get started into Prop 19, I like to start every property tax presentation I do with a reminder on the property tax filing deadlines when you have to file appeals. And this could be very, very important, especially after Prop 19, when there's going to be a lot more changes of ownership that are caused because there's no more parent-child in most aspects.
Thank you, Greg.
So the filing deadlines for the regular appeals, those are appeals that are challenging the value as of January 1 or challenging prior, earlier changes of ownership or completion of new construction, et cetera, are yearly from July 2nd to either September 15th or November 30th, depending upon the county you're in. So most of the Southern California counties are all July 2nd to November 30th. Ventura is not. They're a September 15th county. Some of the Northern California counties like San Francisco, Alameda, et cetera, are September 15th counties. Every year, the State Board of Equalization publishes a list to tell everybody what county has what deadlines. And so those are your yearly filings. In addition to the yearly filings, you can also have outside of the regular roll appeals, and those would be on supplemental assessments and escape assessments. Now, for supplemental assessments and escape assessments, those are generally triggered by either changes of ownership or completion of new construction. When you have a change in ownership and a reassessable change of ownership, the assessor will reassess the property as of that date, regardless of what the date is, and issue a supplemental assessment for the remainder of that tax year, potentially depending on when the supplemental assessment occurred for the next tax year. The supplemental assessment increases the value over the prior Prop 13 trended base year value. And if they take a little while to get around to it, say you had a change of ownership in 2018, but they don't reassess it until today, you'll also get escape tax bills for the intervening years. Same things for completion of new construction. Now, these appeals are different deadlines to file appeals on. They are 60 days from either the notice of supplemental assessment or the mailing of the bill, supplemental tax bill. Same thing, either the notice of enrollment escape assessment or the notice of the mailing of the tax bill. Most counties in California are from the notice. LA County is from the bill. San Diego County actually combines the notice and bill into one document, so they make that easy. But you want to make sure you're appealing the right document within the right time frame. Because if you had something that they reassessed that was actually not a change of ownership, and you fail to file a timely appeal, there's a good chance, even if you later get it reversed, that you will not get a refund for that tax year because you didn't file your appeal. And there's a case, Harmony Gold, which came out maybe 2 years ago now, which confirms that fact. So you really want to be careful. When you get a reassessment, don't just ignore it. 60 days, pretty short deadline. You want to make sure appeals get on file or contact someone to get the appeals on file. The other thing that's a little confusing with that is that counties will also often issue notices of proposed, and when I say often, they have to legally issue a notice of proposed escape assessment before they issue a notice of enrollment of escape assessment. The notice of proposed escape assessment is not an appealable document. So if you get that and file an appeal within 2 days of that, you're probably premature, and the State Board of Equalization takes a position that that filing is void. So you want to be very careful you're filing timely on the right document. And this will matter a lot because, especially for estate planners or people who deal with real estate, where it's like, oh, that used to be a parent-child, it won't get reassessed, we'll figure it out later. Well, now you definitely might want to file, it will be a change of ownership, after February 15th. And also you might have value issues because before you didn't really care what they reassessed the value at. Now you will care. And so even if it is a change of ownership, you want to look closely at the value because there won't be a purchase price necessarily. So there's no purchase price presumption. And so you really want to watch that. So those filing deadlines are extremely important. And I just want everyone to always be aware of those. So, okay, it looks like the slides are moving, so that's good. Prop 19, it was enacted in the November 3rd election. Not by much, just a small majority. Interestingly enough, different versions of Prop 19 have been on the ballot in the past. Prop 19 was sponsored by the realtors with the sole goal of causing people to get reassessed. And because they're reassessed, they can't afford the property taxes, so they're forced to sell the property. Because what happens when you sell properties? There's more commissions for the realtors. And so originally in the past, it was always expanding the over 55 base year value transfer, which this one did, and we'll get to that in a little. But that was the only thing that they were ever trying to do. And that was always a hard pass because quite frankly, there's not really a great policy reason for it. The current over 55, you're basically allowing downsizing and keep your base year. Starting April 1st, you can now, if you're over 55, get a nice bigger house and have property tax savings. But the whole goal again was the realtors. They just wanted people to sell more houses. And if they sold more houses, they could get more commissions. And so, as you see, one of the major selling points was, and if you saw all the commercials, you'd see wildfire relief, Prop 19 protects wildfire victims. Prop 19 did very little for wildfire victims. Most of the stuff there was already there for wildfire victims. The reason they put it in there, and look, it was great marketing, was they could then sell it just as that, and get people to vote for it. I've gotten a massive amount of calls on Prop 19 since it was passed, and it is a significant percentage of people who are so upset about it, but who voted yes on it because they didn't know what they were voting on. They were like, I thought it was just wildfire relief. And I didn't realize it was going to take away the parent-child. My mom's 94. I was going to inherit that property. Now I'm going to have to sell it. Quite frankly, the realtors' marketing strategy was quite brilliant. Now, it might have been illegal, but it doesn't look like any challenge is going to be successful at Prop 19. So we're kind of just stuck with it. But that's kind of where the background on it and why it happened and how it came about came. So it's two major changes to the property tax rule. One is restricting the parent-child, and that's generous. It is almost a complete elimination of the parent-child exclusion. It remains in very limited circumstances, and even then, not always entirely. So the parent-child's exclusion that was enacted back in 1986, just so you know, there was not always the parent-child exclusion for Prop 13. Prop 13 came in 78. Parent-child didn't come around until 1986. So, but it has been around since 86. It's almost entirely gone. And then it does expand the base year transfer generally for people over 55 years of age and older. And we're going to go through both of those in this presentation. This is just the same thing. It was totally put forth by the realtors to increase commissions. And I think it eventually will, because what you're going to see is you're going to see a lot of people who acquire that little strip mall or acquire that little triplex, and their property taxes increase, 10 times, and they're not going to be able to pass it on to the tenants as well as they want, or it's just not worth the hassle for so little cash flow, and it's going to cause more sales. Now, it might not be immediate because, in a lot of cases, you need people to start dying. But I think eventually it will get to the goal of it'll cause more people who inherit property instead of being able to hold it. They'll be able to sell it. Now, the interesting thing is one of the things they like to point out, I can never remember the actor, if it was Jeff Bridges. I think it was Jeff Bridges or somebody who inherited a house either in Bel Air or Malibu and has a super low base year and rents it out for just, some extraordinary sum. And that, whips up a bunch of people about why they hate the parent-child exclusion. The interesting thing is he can afford to pay the property taxes if it gets reassessed. The people who it'll probably nail is just, the regular old people whose parents had saved up and bought a triplex or something like that. And now instead of being able to keep it in the family and have a positive cash flow, they're going to have to sell it when the parents die to pay for the property taxes. So I think the people who will be negatively affected the most are maybe not the people who some of the advertisements were targeting. So background, just to give you a little background on Prop 13 in general. So Prop 13 came in 1978, as I mentioned. You get a March 1, 1975 base year value that can only be increased by at most 2% a year. It's actually the lesser of the inflation factor, or 2%. Just so everyone knows, the inflation factor was barely above zero this year. So your taxes will not be going up 2% this year. They'll be barely increasing this year. And that's your base year value. Can't change. It gives you some certainty and clarity on your property taxes. Now, they are prohibited from increasing the value unless there's a change in ownership or completion of new construction. Completion of new construction is its own potential 1 hour long presentation. And quite frankly, change of ownership, you could do 1 hour long presentations on legal entities, on trusts, on joint tenancies, on leases and step transaction. There's so many different nuances when it goes into what is or is not a change of ownership for property tax purposes. Here's the general definition of change of ownership, and that was formed by the task force in 1978 and adopted in Section 70 of the Revenue and Taxation Code. And that is a transfer of a present interest in real property, including the beneficial use thereof, the value of which is substantially equivalent to the value of the fee interest in the property. It's a 3-element test. You need all 3 properties, all 3 elements to have a change of ownership. Now, I want to point something out that I think is very, very, very important for a lot of you, especially if a lot of you are doing some planning. Property tax, the date of death, if transfer is because of death, the transfer date is the date of death. So if you had somebody die yesterday and the property is still in their trust and it won't be distributed out of the trust for some time because of the trust administration, that property will be able to use the old parent-child rule, because the date of transfer to the kids is the date the person died, not the day it gets distributed out of the trust. 2, for all other transfers, generally, the date of transfer is presumed to be the recording date. So if you guys are doing transfers now, I know there's issues recording things with the LA County Recorder's Office. Now, some of them you might be able to get around with some online filing and stuff like that, electronic services. But if you just send something down now to be recorded at the Recorder's Office, it probably is not going to be recorded before the 15th. And excuse me, the 16th. And so what you might want to do is on the PCOR, which is the preliminary change of ownership report, which gets filed with the deed. On the top of page 2, it says, something along the lines of, if the transfer date's different than recording date, please specify. You should put in the execution date of the deed there. And if you really want to belt and suspender it, maybe have an agreement signed by the party saying the deed was signed and delivered on whatever the day the execution date was. That way, if for some reason your deed doesn't get recorded until after February 15, you have something to overcome that presumption. And I think with COVID, and if you do that on the PCOR, I think you got a really good case that you should be okay for the parent-child. But if you don't do that and it just gets recorded on February 22, I would be very, very nervous that they might try to deny your parent-child because they said, hey, the transfer happened after Prop 19 went into effect. I got a couple of questions. Someone mentioned with Prop 13, if you have a decline in value, the value can go back up more than 2%. Yeah, what can only increase 2% a year is the trended base year value. Obviously, under Prop 13 and then Prop 8, which came in 6 months later, anytime you have a value of a property that decreased in value and the fair market value is less than a trended base year value, you can file a Prop 8 appeal and get a reduction to that number. So your property taxes should always be based upon the lower of fair market value or base year value. Now it's on you to file an appeal to get to the fair market value. And then if you're on a fair market value valuation, they can increase your value more than 2% a year because they're only constrained by the trended base year value. Someone asked on slide 6, the slide we're on, third element, if parent gives house to child and parent continues to occupy house and enters into a fair market lease, do you think the third element is satisfied? I assume the third element to the child, and yes, collecting rents and owning the property is substantially equivalent to the fee. Now, what you would be worried of is you enter into a lease that's 35 years or more with the parent, then the parent becomes the owner again. But you could transfer the property to a kid and then the kid could rent it back to the parent. That's no problem. That still would be a full transfer to the kid. So just a little background on trusts. If you transfer it in and out of a trust or termination of trust, generally that's a change of ownership, but that general rule is kind of swamped by the exceptions to the rule. The most important thing for trusts is if you can revoke the trustor is the owner for property tax purposes. We look through trusts in property tax world. We kind of look right through them to see who the owner is. So a trust that can be revoked, the trustor is the owner. For an irrevocable trust, a trust that cannot be revoked, the current beneficiary is the owner. So that's the most important thing. The trustee is never the owner in its capacity as trustee. Now, the trustee could be the trustor of a revocable trust, and then they're the owner. But in their capacity as trustee, they're never the owner. And if you have an irrevocable trust and the beneficiaries change, that's a change of ownership, because it's just as if they owned it and transferred their interests. So for trust, the most important thing to look at is who is the trustor, who is the current beneficiary, not a future beneficiary, but the current beneficiary. Someone said, if someone dies today, you're still certain they have 3 years to file the claim. Yeah, and the state boards have even actually already issued guidance that the filing deadlines haven't changed. So yeah, if they file today, you still have 3 years, or before it transfers to a third party, or within 6 months of a notice of reassessment, if you're outside of any of those deadlines, to file and still get fully retroactive effect. So parent-child exclusion, this is the current law that will exist until February 15th. And I'm aware February 15th, I think, is a President's Day. So it might be hard to get things recorded on that day since all the offices are closed. So keep that in mind. But, if someone dies on February 15th, look, if someone's about to die around midnight, hopefully they go at 11:59 and not at midnight, because if they die on the 15th, you'll be able to be under this old law. Section 63.1 says no change of ownership when you have transfer between parents and children. By the way, it does work both ways. You can go parent to child, child to parent. The grandparent-grandchild only goes grandparent to grandchild. It does not go the other way. But parent-child does go both ways. You can transfer a principal residence, no matter what the assessed value is, doesn't matter. And you can transfer $1 million per parent of trended base year value of all other non-principalized real property. And that's really important, that it's the trended base year value and not the fair market value. So if you have a property that's assessed at $400,000, but is worth $4 million, a parent can transfer it and they'll only use up $400,000 of their million. And it is per parent. So if you have a married couple, you have $2 million between the two of them. But it's not per child. Sometimes people get confused per child. Someone asked if the beneficiaries are children of a trust, does the parent-child apply? Yes, trust, again, we just looked through it. So you transfer a property into if a parent transfers property into an irrevocable trust, and the current beneficiaries are the children, that's the same thing as transferring property from the parent to the child directly. And so you do get the parent-child exclusion there. Principal residence. Generally, you want to have the homeowner's exemption on it. The homeowner's exemption is a $7,000 value exemption. So it's only roughly, $80 a tax, depending on your tax rate that you save every year. Interestingly enough, when it was enacted, I think the average value of a home was $12,000. So it used to be almost totally exclude the value of homes from property tax, but obviously it hasn't changed since then and doesn't do much anymore. But it's important for the parent-child and the principal residence. And the principal residence only includes the reasonable size of the land underneath. So you just can't go buying up all the houses around you and just saying, oh, they're all my principal residence, because they're all contiguous. So that's important. Next slide. Child. Any child born is extremely broad. Extremely broad. Any child born of the parents, obviously natural, any adopted child, any stepchild, any son-in-law or daughter-in-law, they're all children. They're all the same for property tax. And the only thing is a child adopted after the age of 18, so after they've achieved adulthood, obviously would not count as a child. I didn't even think that was a thing, but I actually had someone who called up and they were adopted after the age of 18. So it does actually happen. So example, under the old law, mother transfers 100% of Blackacre to child, and Blackacre is the principal residence. Assessed value is 3.5 million. Fair market value is 8 million. That is not a reassessable event. By the way, some people have asked questions upon step up in basis and everything like that. I'm only a state and local tax attorney. I do not do any income tax. I can't comment on step up in basis. I can't comment on gift tax. I can't estate tax, nothing. So I'm not going to comment on any of that. That's what is outside of my area of expertise. I can only comment on whether it works for property tax. Whoops. Not if it works for anything else. Okay. Well, one person asked the deadline to file a parent-child exclusion. I think I just already referenced that, so that should have been answered. Example 2, mother transfers a property. It's not a principal residence. Assessed value is $350,000. Fair market value is $1.2 million. No reassessment there, assuming the mother had her $1 million left, but $350,000 of the $1 million would have been used. In the past, obviously, people sometimes would be very wary about using up their $1 million. Not really an issue anymore because the $1 million goes away February 16th. So I don't think you have to worry about saving the $1 million for future transfers. So effective 2/16/21, the parent-child remains in a very, very limited fashion. So any property that's not a principal residence would no longer qualify for the parent-child exclusion. That is just gone for any non-principal residence property. Also, if a principal residence transfers to a child and that child does not use the property as their principal residence within a year, no parent-child exclusion. The only way you get the parent-child exclusion is if the parent's principal residence is transferred to a child and the child then uses it as their principal residence within a year. Now, one good question is, well, what if it goes to 4 kids and only one of them uses it? Do they all need to use it? Does one need to use it? Totally unanswered in Prop 19. Who knows is the real answer. Now, the state board has already kind of opined that if only one of the 4 kids lives there, you should get the exclusion. Now, how do you calculate that? We'll get to that in effect. Who knows? I mean, there's going to be a bunch of clarifying statutes, regulations, and guidance that come out eventually. I'm actually speaking at Eagles Lodge West at the end of February, which is a meeting between the state board and assessors and some private practitioners, and we're going to talk about, maybe what the best ways and regulations and stuff are to go about this. Of course, that doesn't do us much good because that's after this all goes into effect. So everyone on here, you're going to be totally flying blind until Prop 19 goes into effect because they're not going to get anything out in time. But right now, the state board does take a position that if one kid lives there. Now, someone asked a good question. How long do they have to live there? Good question. They live there a day and then move. Now you'd have to live there, actually move there, get the homeowner's exemption on it, which, you're testifying on a penalty of perjury that is your home, change your license, your voting registration. I mean, I don't think that'd be worth it to do it for a day. But what if you live there for 6 months, a year, 2 years, and then you decide to rent it? No one knows. It's not clarified in Prop 19. I'm of the opinion that if you get the parent-child and it's approved and you did live there and then you move, they can't reassess it because there's not a change of ownership. They're still bound by the Constitution. You're moving out and then renting the property doesn't change it. Now, I don't know if they'll come out with something that says, hey, we want you to live there for, a year. Otherwise, we don't think you actually live there. I think that would be in the purview of the legislature to do, or even this SBE and interpreting Prop 19. But at this point, the answer is we don't know. Prop 19 was not the best written prop. Again, it was done not by property tax experts, not by anybody. It's done by realtors to get sales. So a lot of these questions just aren't answered. And as I mentioned, they do adjust, by the way. So for the parent-child exclusion, if it is the principal residence, it's also not a guarantee. You only get your base year value plus $1 million. If the fair market value is within your base year value plus $1 million, you get the full transfer. But if it's over that, and we'll go into some examples to explain that, you're going to get partially reassessed. That's why I said that happens a lot of times too, just because the home values have gone up so much that even in a lot of cases, if the kid does use the property, there's still probably going to be some partial reassessment on that property. Now, unlike the $1 million exclusion in the current parent-child for non-principal residence property that was never adjusted since 1986, the $1 million in Prop 19 for the principal residence is going to be adjusted annually by the State Board of Equalization. So it should kind of tick up every year. But that's, I mean, look, if you had a parent who bought something in 1982 and they bought it in a fairly nice area, that property is worth probably way more than $1 million over its base year value at this point. These properties have just increased by that. The $1 million for the parent-child exclusion is totally eliminated. Parent-child transfers. Example 1, mother transfers 100% of Blackacre. This is Prop 19 transfer. So under the new law and how it works, mother transfers 100% of Blackacre to child, and child uses Blackacre as principal residence. Let's assume the assessed value is $3.5 million, and that $1 million addition had been adjusted up to 1.1 because it's a few years in the future. If the fair market value is 1.2, you'll have no reassessment there because 350 plus 1.1 is more than 1.2. Even us lawyers can do that math, hopefully. Other example, it's the same exact facts, but assume the fair market value is $2 million. Well, there you're getting, you are going to get partially reassessed. Now, you're not going to get reassessed up to $2 million, the fair market value. You're going to keep the 350, and then it's the difference between the 1.1 plus the 350, so that's 1.45 million. 2 million less 1.45 million is 550,000. So 550,000 plus 350,000, that's your new base year value, $900,000. So you're still getting a benefit in that case. I mean, you'd be saving, $11,000, $12,000 a year of property taxes than if it was reassessed completely to the fair market value. But in the past, you'd only be taxed at $350,000, and so your taxes are going up, roughly $6,000 a year, where they would have gone up $0 a year. So you're certainly not as well off as it could be. Someone asked, what do you hear about legislative actions to reverse the delay or reverse or delay Prop 19? I don't see how a legislature could reverse or delay Prop 19. Prop 19 is a proposition that changes the statute. I think they'd have a hard time doing that. I know that people are looking into it, and I know Jeffrey Prang, the LA assessor, had put some stuff up there. I don't think you can, at this point, you cannot bank on the parent-child exclusion being there after February 15th. Everyone should assume that Prop 19 is going to take effect on February 16th. Okay. Someone mentioned BOV opinion says if child moves out, no reassessment, reverse the base year value when transfer occurred as opposed to older base year value. Yeah, that was Richard Moon talking, and he's just wrong there. I think that was taken out of context. You can't reassess when a child moves out unless there's a change of ownership. I think that's just 100% legally wrong. I think it was in conversation and not stated correctly. So if a child moves in, they get the parent-child because it's a base parent-child exclusion transfer, and then they move under Prop 19, and then they move out later. Unless they change the law, you can't reassess when they move out because that's not a change of ownership. So, I mean, you can't change the fact that the other one was a change of ownership and that wasn't. You can't retroactively go and reverse it under the current law. I think that was just a misspeak at the state board because they were getting blasted with questions, and I think they just kind of overstated something. Someone asked, does this change the rule? And a lot of people have asked, does this change the rule with joint tenancies? No, Prop 19 doesn't change the rule for joint tenancies. So if you have a property and you add a kid as a tenant in common, and then you transfer it into a joint tenancy, parent and kids, and then the parents dies, there's no reassessment because the parents and kids were both original transferors. Now, don't be confused. If you have a parent who then transfers it to a joint tenancy for parent and child, that is not reassessable. But when the parent dies, it will be reassessable because that kid is not an original transferor. So the joint tenancy rules, which I don't have in this slide deck, are very confusing and complex. So it's not as simple as, we'll just transfer it to a joint tenancy. I'm a parent, I own the property, let me put it into a joint tenancy with my son. You have to follow 100% correct steps to do that. And you might even cause reassessment after February 15th if you don't do it correctly. Someone asks, is there a grandfathering in of Cuperts? No. Cuperts, you're going to be in trouble. And we'll get to that in a second. There may be ways to plan around. A lot of people have asked a bunch of different questions. A lot of people are really hot on intentionally defective grantor trusts, which generally are parent-child transfers because they're irrevocable trusts and the children are the current beneficiaries. However, they might, for other reasons, stay in their parents' estate. That's outside of my areas for step-up and basis or something like that. Be careful because some people are getting a little aggressive and they're putting, all the income retains with the parent and all that other stuff. And some of that stuff might be interpreted that the kids really aren't the beneficiaries. So be a little careful with what you're doing on some of those. But I know those are a hot topic. You could transfer property to the kids now, and then you could have the kids a week later transfer back an estate for years to the parents for under 35 years. Estate for years for under 35 years is not a reassessable transaction. And so the parents, if they're elderly, that probably is going to, if they're 75, that probably covers them. And so, you could use the legal entity rules, because transfers of entity interest have special rules. So there are potential ways to plan around it. There's a lot of ways to plan around it for property tax. Maybe not all those ways might work for other taxes. And so, I could come up with a plan for property tax, but, one of you on this Zoom could say, but Greg, that's horrific for income tax purposes or gift tax, for all I know. So you want to look at everything when you're doing this stuff. Obviously, with anything you do, proper documentation, timely submissions are critical to avoid a change of ownership. If you don't timely file for the parent-child, you don't do things in the proper order. If you're trying to use the rules, you want to look at everything extremely, extremely, extremely closely. So here's the Cupert. So Cuperts used to be fine, right? You transfer it into the Cupert. It's not a change of ownership when it goes into the Cupert because the parents still have the current interest in the property. And then when it goes out of the Cupert at the end of the term, in this case, it's a 10-year term, it's a transfer to the children, but no one really minded because you could file for the parent-child exclusion at that point. Well, those problems come around. Someone asked just real quick, wasn't the adjusted 1 million 1.35? No, because if you read the question, I had the million being 1.1. So 1.1 plus 350,000 is 1.45 million. So now with Cuperts, if they expire, the term expires after February 15th, it goes to the children then, and there's no parent-child. And so, yeah, Cuperts are going to be a big problem. Now, if you can terminate it now, it goes back to the husband and wife. That's not a change of ownership. And then you could do some planning now. I know that isn't always feasible on some of these Cuperts. So I think in a lot of these things where, it used to be, you'd get the parent-child, now you're not. And so now the children are going to, have an increase in property taxes, and not even just the children, because usually the parents are actually typically still alive then. And so the property taxes are going to generally trigger up. So Cuperts aren't all that great of an option. And it really stinks because it'd be great if the legislature did do something about that, because when these were all designed, obviously no one had any sense that there wouldn't be a parent-child when the Cupert term was going to end. But that's where we are right now. Same thing with GRATs. When they terminate at the end of the term, you're gonna have a change of ownership because there's no more parent-child exclusion, after February 15th. I'm getting a lot of questions on there. Some of them are very specific, so I don't think I'll maybe leave those and you can give me a call or something at a later time. Someone did ask if a parent sells a property under Prop 58, so this is before February 16th, which has an extremely low base year value, and they sell it to the child, you still get Prop 58. Yeah, for parent-child exclusion purposes, it doesn't matter if it's a gift, inheritance, sale, nothing matters. It's just the transfer. So long as it transfers between the two, you're fine. Someone asked, where are they going to come up with the base year value, the fair market value for these properties? Well, the assessor does this all the time because there's transfers all the time that don't have purchase prices that cause reassessments. And the answer is they're going to look to the market. They're going to use either the comparable sales approach, the income approach, or the cost approach. For houses, they're going to use the comparable sales approach. For income producing properties, they'll generally use the income approach, maybe special purpose cost approach. But those are the only three approaches that the assessors are allowed to use. But they're going to look at the market to determine what the market value of the property is. And so if you have a property with below market leases, they get to ignore those below market leases and assume your property has market leases and value it at that way. So it's vice versa. If you have above market leases, they have to assume market leases. So, you could think it's worth one thing in the real world, it could be worth a lot more in property tax world. So the next thing they did, which is actually pro-taxpayer, is they extended the over 55 base year transfer. Excuse me. The over 55 base year transfer currently allows a homeowner who's 55 or older, shocker by the name of the title of it, to transfer their home, the base year value of their home, to a new home, so long as the new home is of equal or lesser value, and that's a little deceiving, to the value of the old home. And that's on fair market value, not the base year value. Basically, the over 55 exclusion was done to encourage elderly people to downsize, because what was happening is you had people, I'm living in this 4,500 square foot house, but I'd rather move to a condo in the desert because I just don't need that space anymore. I'm 72 and retired. But I don't want to go from paying $2,000 a year in property taxes to going to $12,000 a year in property taxes when I'm going to a much smaller house. So the over 55 was allowed for that to happen, so long as you went equal or lesser value and were in the same county, unless the county had enacted reciprocity. And so most of the Southern California counties have reciprocity. A lot of the Northern California counties don't, but look, we're the Beverly Hills Bar Association. We all live in Southern California. Let's be honest, none of us would ever retire up to Northern California. Gross. Just kidding. But in all seriousness, I mean, you can go almost anywhere in Southern California and get it, but maybe not in Northern California. So that was the old law, and that law is in effect until March 31st of 2021. And equal or lesser value to is a little deceiving. You had to do this transfer within 2 years of each other. So you had to, once you sold your current house, you had to either have bought your new house within the prior 2 years or within the next 2 years. If you bought it within the next 2 years, if you bought it within 1 year, you got 105% to be equal or lesser value. And if you bought it within year 1 to 2, it's 110%. So they did allow some inflation, so you could kind of take that into account. I actually had someone call me one time who was buying their new house, and they were going to buy the old new house and then sell the old house in that order. But he was buying it for slightly more. He literally, all he had to do was flip the order and he was going to get it. So we had him change the order of the day they were doing it because they were fine. They didn't need to sell their house to do it. And they were able to get it. So you do want to be careful with that, or at least careful with that for the next little bit. Again, it's 2 years, needs to be bought or newly constructed. So if you're doing construction on a new house, the construction needs to be complete, which is generally certificate of occupancy, within 2 years of the date you sold your old house. So starting April 1st, 2021, massive expansion to the over 55 base year transfer. If you're 55 and older or disabled or natural disaster, but generally this is going to be for people who are over 55. In the past, you could only do the over 55 base year once, and that's it. Once and out. Now you can do it up to 3 times. Also, just so everyone knows, you can't transfer your home to your kids. They get the base year value on the home and then also transfer the base year value via an over 55 base year value transfer to a new house. It's one base year value. It either stays with the old home or it goes to the new home. My opinion, take it to the new home, make your kids pay the higher property taxes. So now you can do it 3 times. So you can sell your home and go get another home and go, I hate this home, let me move again. Also, it allows finally for those strange people, and some people booed me on the chat. So for those strange people, I'm just joking, obviously, who wanted to go up to Northern California, maybe wine country or something, you can now go anywhere in California starting April 1st. So you can do the base year transfer to any county in California. You could even go up to what I like to call Southern Oregon, those counties with nobody up there where no one really lives. Also, you no longer have the equal or lesser value. So this, again, now you can go buy a much bigger home. So it's like, hey, you know what? I got some money. I like my home, but I like that mega mansion better. I'm going to go buy it now because I get a property tax savings just because I'm over 55. So if you're 54 and you're looking to move, just wait until you turn 55. You get property tax savings. So it's still, if the new home's equal or lesser value, you get the full exclusion. What happens is if the new home is more expensive, you get to transfer your base year value up to the fair market value of your current home, and then you just get the delta increase. So if your current home's assessed value is 100,000, I'm just going to do really easy math so I don't have to complain and everything. I mean, if 150,000 homeowner sells the old home for 500,000, purchases new home for 400,000, look, you get to transfer everything, right? Because the new home is actually worth less than the old home, so you get a full base year transfer in this example that's up on the screen. So that's no different. That's the same thing. You can still downsize and get the same house. The only benefits you get if you're downsizing is you can do it more than once. So if you downsize and really don't like your house and want to move again, I moved to the desert. I hate the desert. I want to move back to the beach. You can do it multiple times, and then 2, you can move to any county you want, which is nice. However, if the assessed value was 150,000 and the old home sold for 500 and a new home sold for 900, and I know, look, for all of us in LA County, I need to add another 0 for the prices of the houses. But I just wanted to do real easy math. You would get reassessed on the difference. So you'd add the difference between 900 and 500 is 400. So you'd add that delta to your old base year value. So now you're at a $550,000 value. So you're getting a benefit. I mean, look, under the old law, you would have been reassessed at 900,000. So your taxes would have gone up roughly $8,000 a year. Now your taxes are only going up, $4,500 a year, depending on tax rates, which can vary slightly from every area, depending on the voted indebtedness of that area. So it is a much better benefit. Now, you still need to, like the parent-child, this is not an automatic statute. You have to file a claim for it. Usually it's I believe it's within 3 years. So you do need to file a claim for it. But I would say to all of you, anyone who's 55 or older, who's buying, moving, not just buying property, but moving from their principal residence, they now should be filing a claim in every instance, because in every instance, they're going to be, as long as they're 55 or older, they're going to be able to get some benefit. Now, what's interesting is, well, what if I sold my house today and bought my new house in April? Do I get the Prop 19 rule, or am I under the old rule? That's a great question, because that's the first question I asked. And the state board just opined saying, we don't know, because it doesn't say. I kind of the opinion that if you did one after April 1st, I feel like you should get it. But I don't know what they're going to do there, because it really is unclear if you need to do both or just one after. I think the better might be if one is after, but they might go with 2 because that's a little less taxpayer friendly. So that's something you want to keep in mind. Someone said, if you've taken a base year value to a new property, lived there for many years before dying, what is the base year that the child inherits? Up until February 16th, the base year the child inherits is that low base year. So just because the child can't take it if you're going to go transfer it somewhere else, if you transfer your base year somewhere else, or have already done that, and then you die today, your base year goes to your kids under the parent-child exclusion. Obviously, that changes after February 15th. So one thing I want to mention is, and I've kind of mentioned this throughout, but I think it's important. Prop 19 is extremely big, extremely big. It is not detailed. It doesn't cover every potential scenario. Quite frankly, the parent-child as written doesn't even, the current one doesn't. I mean, if you go on the state board's website, there's hundreds of annotations and guidance on the parent-child exclusion. I fully expect there to be clarifying statutes that come from the legislature, clarifying regulations that come from the State Board of Equalization. And just so everyone knows, regulations that come from the State Board of Equalization are binding law. They are law that are binding on the assessor and the Assessment Appeals Board. Now, regulations cannot go outside the statute. They can't expand or narrow a statute, but they are binding law. And the only way if an assessor disagrees with them is they have to file a 538 action and sue the State Board of Equalization. They can't assess you in contrary to a regulation. Compare that to guidance that the State Board issues. The State Board issues letters to the assessors. They issue annotations as well as the backup letter to the annotations. Annotations are basically annotated legal opinions. They also issue things such as the assessor's handbooks, which are kind of on specific topics. There's a change of ownership handbook, there's a new construction handbook, there's a valuation handbook basic, there's an advanced valuation, there's valuation of oil producing properties, there's valuation exemption handbooks. There's a bunch of handbooks which are very detailed on specific issues of property tax. Those are guidance. They are not binding law. Now, generally they're followed. Now there's 58 different assessors, because there's 58 different counties, and 58 assessors can take their own interpretations on this stuff, and they do not have to file those. But generally they are followed, and generally courts will follow them, but courts do not have to follow them if they don't want to, because they're not binding law. I do expect a significant amount of annotations and stuff to come out too. I do not expect any of this to happen all that quickly. The reason being is, one, government doesn't act quickly, just a general statement. Two, the State Board of Equalization was almost entirely gutted. I think it was either back in 17 or 18, I can't remember the exact year, because the State Board used to do the franchise tax appeals after it left the Franchise Tax Board. They used to do all the sales tax, and the state ripped all of that away from the State Board, which is a constitutionally created entity, and created the CDTFA and the Office of Tax Appeals. So the State Board was totally gutted. And all that remains at the State Board generally, other than some random cigarette taxes and stuff like that, or timber taxes, is property tax, state assessed appeals and valuations for state assessed property, not locally assessed property. And the people who issue the guidance and everything like that. But there is not many of them left. They are extremely backed up. They have tons to do. I remember Henry Nanjo had made the comment to me, and he's the chief counsel of the State Board, that at one time he felt like he was running a solo practice running the State Board of Equalization. It was just, that's how much work they had to do and how little help they have. And so I'm sure a lot of it will come out eventually. The problem is I'm not sure any of them will come out when it can actually be helpful, especially with, I see so many questions, well, what if I do this? What if I do that? What if I do this? You're going to be flying largely blind on a lot of this stuff, because there's not going to be a ton of stuff coming out before February 16th. And look, you don't have much time. Let's say the 21st. I mean, if you need to get things doing, I'm sure all your state planners are running wild on this. You're going to be in trouble. Now, someone said, can a grandchild take advantage of the parent-child exclusion after 4/1? No, they also can't take advantage of it after February 16th. Remember, the parent-child in all shapes goes away February 16th, and the grandparent-grandchild exclusion goes away February 16th. So these are things that go away almost entirely February 16th. So Someone sent me a flyer from realtors saying, "Oh, the parent-child goes away March 31st." They're flipping the dates. The over 55 is April 1st. The parent-child is February 16th. So these dates are really, really important. There's a lot of ambiguities in the proposition. If you're advising clients, your best you can do, I think, in a lot of these situations, is say, look, under the current reasoning, under the current reasoning, it looks like it might be okay, but who knows? And we also don't know. There's all these transfers with step transactions. There's an uncodified provision of parent-child which says step transaction doctrine shouldn't apply to parent-child transfers. Does that still exist after February 16th? Probably not. Maybe. I don't know. I mean, it's unclear. And will assessors get more aggressive on those step transaction type of transfers when there are parents and children involved and legal entities and everything like that? Will they get more aggressive in looking at trust and saying, hey, that limited power of appointment, that's really a general power of appointment. And so I'm viewing that person as the owner, not the person you're telling me as the owner. I don't know. I mean, each assessor will treat this differently, but I could see them getting more aggressive on some of this stuff. I could see a lot of things happening. So it'll be interesting what happens. The problem is, and I know this is not what you want to hear, is you're going to be flying blind a little bit. So just be careful. Okay. I think with that, there's only a minute or two left, and I know there needed to be some closing remarks. So thank you very much. I appreciate being able to present to all of you.
Hi, everyone. Thank you so much, Greg, for that presentation and for your expertise. Thank you to all of our attendees today. You will receive a request to complete a survey. So please let us know how we did. I'm Elizabeth Dryden. Enjoy the rest of your day.